Hi, everyone, and welcome to our webinar on the recent federal action on Tobacco 21 and the FDA flavor guidance. I'll just reiterate a little bit of what Stephanie just mentioned. All attendees are muted at the moment. If you want to ask a question, please just use the Q&A question button at the bottom of the window. And while we might not be able to get to all your questions, we'll try, but please feel free to reach out to us afterwards if you have any questions. The webinar is being recorded, so if you'd like to share it or view it later, we will be sending out a link to the recording. And finally, a short survey will be popping up on your screen after you exit the webinar. Please take a couple of minutes to fill out the survey. It would really help us improve future webinars. Founded in 2000, the Public Health Law Center is located in St. Paul, Minnesota at Mitchell-Hamline School of Law. All the work that we do here at the center is grounded in health equity. We work with communities and organizations in using law and policy to address the social determinants of health, which means meeting the specific needs of all communities, especially those that unfairly bear a disproportionate amount of public health and other societal harms. We offer free legal technical assistance, which means we help with research and policy drafting, issue publications, and conduct trainings and webinars like this one. We do not directly represent clients, nor do we lobby. If you have any additional questions, please check out our website. We have some new resources, 2 blog posts on the issues that we're going to be talking about today, and some additional publications regarding pre-market review of e-cigarettes. So here's our agenda for today. I'm going to be turning it over shortly to Desmond Jensen and Natalie Hemmerich. Desmond is lead senior staff attorney for federal regulation. Natalie is a staff attorney who also focuses on federal regulatory issues here at the center. So turning it over to Desmond.
Thanks, Kira. So today we have a lot to cover. We're going to be talking about the FDA's action on flavors in the form of final guidance that was issued and the new federal Tobacco 21 law. But before we get to those policy changes, we want to talk about the youth e-cigarette epidemic as a whole, because it's the backdrop for what the FDA is doing, and it informs the regulations and the actions that the FDA is taking. So you all probably remember the 2018 National Youth Tobacco Survey data. So the reason we reached back this far is because this is the data that convinced the commissioner of the FDA, the Surgeon General, and other public health officials to start using the word epidemic when it came to youth use of e-cigarettes. And as you all know, the 2019 data is out as well. We've just overlaid that data onto the 2018 graphic here. You can see that use of e-cigarettes, as we all know, has continued to rise, but use of other products has actually declined. And then with cigars and pipe tobacco, usage was flat. And so it is the increase in e-cigarettes that is driving the increase in any tobacco product use. But to really look at this in a more complete picture, we can actually reach back even farther. So what you'll see on this slide is all of the National Youth Tobacco Survey data going back all the way to 1999. And before 2011, the survey was not conducted every year. So there's some holes in this information, but this gives you a really good idea of the long-term trends. And it's important to recognize that we have made tremendous progress when it comes to youth use of cigarettes. We went from the 1999 survey having more than a quarter of high school students smoking cigarettes to now almost 5%. And 5% is an endgame goal. However, as most of you know, cigars often fill the gap when it comes to cigarettes when we enact strong regulations. And for the last 6 years, we really haven't made much progress on youth usage of cigars. And in fact, this year, cigars are now the most commonly used combustible product among high school students taking the survey. And so we need to really work on cigar regulation as well when we focus on combustible products. And of course, what we're here primarily to talk about today is the increase in e-cigarette usage. This went from a product that did not exist a short time ago to now being the most commonly used tobacco product among high school students. So when you put those three product categories together, the trend you get is this on the left. Usage of any tobacco products was declining. We made tremendous progress, and that progress has essentially been erased. We are back to a point where almost a third of high school students are using tobacco products. And you have to go back all the way to the 1999 or the 2000 National Youth Tobacco Survey to find a higher rate of any tobacco product use among high school students. And that was a long time ago. For context, I was a high school student when those two surveys were issued. And now I'm a mostly grown-up adult, and I've been practicing law for a few years. So the progress that we've made over the last 2 decades is been erased, and we are currently on a trajectory that is negative. Now, to really understand what's happened in the last few years with e-cigarettes, I think it helps to also look at this information. So what you're going to see on the next few slides is e-cigarette sales data. This is Nielsen data, and it's all channel data. So that means it's convenience stores, big box stores, pharmacy chains. The data does not include vape shops, and it doesn't include online sales. So it's underrepresented, but this does give you still a good sense of the long-term trends. So the blue area on this chart is sales of all brands combined. And what you can see is that from November of 2013 until August of 2016, the market was essentially flat. There was very little growth. About $50 million in e-cigarettes were sold every month, and that remained fairly steady. But this is where we are now. In the last few years, the market has increased by a factor of 8, peaking at over $400 million per month in sales. And you can essentially attribute all of that growth to Juul. So the red area on this chart represents Juul sales, and again, the blue is all brands combined. So not only has Juul driven the market to new heights, but it has also, you'll notice that when Juul sells fewer e-cigarettes, the market shrinks. So Juul sales are entirely driving the market. And actually, if you look at where the other companies are in comparison to Juul, they're barely there at all. In fact, the only times you can sort of see one company or the other peaking out over the other companies is when they've introduced a Juul knockoff product. So the only times that they can even outcompete each other is if they're trying to do what Juul has done. So now let's use the market data as a backdrop for looking at youth usage. So we'll bring back in the NYTS data. So the green line at the top you'll see is high school users, and the yellow line at the bottom is middle school. And high school usage has been grabbing the headlines. Those are the rates that you see when there's news coverage of the NYTS. But it's also worth noting that there are now over 1 million middle school students in our country who are using e-cigarettes. And those are 6th, 7th, and 8th graders. Now, if you take the two groups, and by the way, these are population estimates rather than rates, and you'll see why in a minute. But if you take these two groups and put them together, you get a decent approximation of the total youth usage. So you can see that while Juul is growing, youth usage is increasing. So there's a direct correlation here. It's fairly obvious to see. I should also mention the market data and the usage data are on 2 different y-axes, so they don't relate to each other in any way, but when you put them on top of each other, you can see how they're related in terms of time, because they're on the same x-axis. So the time scale is shared. Now, we also know a bit about adult usage from another survey called the National Health Interview Survey. Now, these two surveys use different questions to get at e-cigarette use, but the way that the questions are different are consistent with tobacco product use among youth and adults. So even though these aren't apples to apples, we can still use them for the long-term trends. There's a lot going on this slide, so don't try to follow all of it, because really what we want to do is to isolate older adults from youth and young adults. So if you see the black line at the top, this is older adults. So this is adults who are 25 and over. And you can see that over the past few years, with the exception of 2018, as we move along in time, there are fewer older adults who are using e-cigarettes. That's not true for young adults. That's the purple line on the bottom. For young adults, there are more users over time as well. So the trajectory there is up. Now, I want to combine the youth and young adult data together. And there's a couple of reasons why I think we should do that. First, young adults have been actively targeted by Juul. They're susceptible to tobacco marketing, just like youth. And there are actually plenty of young adults aged 18 to 24 who initiated with Juul while they were youth, and they've simply aged into this older category. Now, if you combine youth and young adults, you'll notice that through 2018, we reached a point where those two groups were approximately the same size. So the number of youth and young adults using e-cigarettes is about the same as adults 25 and over. And it's important to realize that those two age categories are not the same size. In fact, there are more than twice as many adults 25 and over as there are youth and young adults in our country. And so that means that even though there are about the same number of e-cigarette users, the rates are very different. So about 2.6% of adults 25 and over are using e-cigarettes, but for youth and young adults, it's something like 7.3%, which is almost 3 times more. Now, back to the graph here. So if you sort of try to move forward past 2018, and unfortunately we don't have adult data yet for 2019, but if you assume that the recent trend, the upward trend for older adults is sustainable, and it might not be. In fact, probably a lot of the growth in that category was people who were 25, 26, 27. It's probably not a lot of 45-year-olds or 40 to 44-year-olds who are using these products. But if you assume that that was sustainable growth, and that next year there will be the same increase from 2018 to 2019. Again, we don't have adult data, so we can't know how many young adults are using e-cigarettes in 2019. But if you assume that young adults are the same, but you include the increase among youth, you can see that in 2019, we likely reached a point where there were far more youth and young adults using e-cigarettes than adults. So not only do we have a youth e-cigarette epidemic, but we have a situation where youth and young adults are the primary users of these products. And it's also important to think about the fact that nothing that our government has done up to this point has really addressed this problem in a comprehensive way. The FDA has made a lot of headlines over the past couple of years, but their actions have not stopped the growth of Juul sales. Now, you'll notice that there are 2 points on this graph where Juul sales dipped, and the market as a whole did as well. One of them is related to Juul voluntarily discontinuing some of its flavors in retail stores, which we'll talk more about in a few minutes. And the other directly coincides with the increase in, with reporting of lung injury as a result of e-cigarettes. So this is simply people buying fewer e-cigarettes out of fear. And neither of those were government actions. So the only times that Juul has sold fewer e-cigarettes, it was not related to actions by the federal government or state governments. So now as we start to talk about FDA regulation, regulation is an unfortunately vague term. It can mean a lot of things. And it's actually the level of regulation that makes sense. The fact that there is regulation of a product doesn't mean that we can't have problems with that product. The FDA also regulates drugs, but as you all know, we're in the middle of an opioid epidemic as well. So what does FDA regulation of e-cigarettes look like? Well, this is essentially the extent of e-cigarette regulation right now. Since the FDA started regulating e-cigarettes, there's been a minimum legal age of sale, which has obviously just increased, which we'll talk about more. There's a prohibition on some vending machine sales, prohibition of free samples. Manufacturers are required to register with the FDA and provide lists of products and ingredients, but that self-reported information is not necessarily verified by the FDA. And then, of course, there are required warning labels on products. But as you can imagine, none of these policies individually or collectively are going to address the epidemic that we're facing. And the FDA has a lot of authorities that it could use to fully address the epidemic, but the one that we're going to focus on and the one that the FDA is using is pre-market review. And so we have to talk a little bit about the background of pre-market review in order to really understand what the FDA has done with flavors in particular. So the FDA's pre-market review of tobacco products is supposed to sort of look like FDA pre-market review of drugs, where a product can't enter the market at all until after the FDA authorizes its sale. But how that authority gets implemented is going to determine whether or not this policy is successful at protecting public health. So what you need to know is that the Tobacco Control Act gives the FDA pre-market review authority over new tobacco products. And a new product is one that was entered the market after February 15th of 2007. So products that were on the market before then are grandfathered. They're not subject to pre-market review, and those companies can keep selling those products without FDA authorization. Now, the e-cigarettes that are on the market now were not on the market in February 15th of 2007, which means they technically need permission from the FDA before they can be sold. We'll circle back there in a second, because you also need to know that when the Tobacco Control Act was passed, it only gave the FDA immediate authority over cigarettes, cigarette tobacco, smokeless tobacco, and roll your own tobacco. For everything else, the FDA has to deem a product to be subject to its authority. And if the FDA doesn't regulate a product, a manufacturer can't even ask the FDA for permission. You can't actually even file a marketing application. And so hopefully you can see there's a sort of catch-22 here, where you can't ask for permission until the FDA regulates, but once the FDA regulates, you can't sell your product at all until that permission is granted. And so the FDA has used enforcement discretion to implement pre-market review for e-cigarettes. And initially, that's what this is what pre-market review enforcement was going to look like. So this is what the FDA wanted to do with the final deeming rule in 2016. They would allow manufacturers to keep products on the market for about 2 years, and then they had to file applications. The filing of an application allowed a manufacturer to keep their product on the market for 1 more year while the FDA was reviewing it. But at that point, the product should be removed from the market if it didn't have marketing authorization. But unfortunately, this was never fully implemented because, as you all know, in 2017, the FDA introduced its new regulatory plan. It was going to address nicotine levels in combustible products. It's going to address flavors in tobacco products, and it was also going to completely rework pre-market review. And this is what that plan looks like. And you can see there are 2 really important differences. First, it pushed the deadlines out for marketing applications far into the future, to August of 2022 for non-combustible products. And more importantly, this plan does not have a date where a manufacturer must have secured marketing authorization before a product can be sold. So as long as a manufacturer filed their application in 2022, they could market their product indefinitely while the FDA is reviewing it. And that review can sometimes take years, has in the past. So this was a damaging plan in terms of protection of public health. So damaging, in fact, that public health groups actually filed a lawsuit against the FDA, challenging that action. We don't need to talk about the legal arguments that were made, but public health groups did win that lawsuit. And the court in that case has imposed a new plan for pre-market review. So this is the one that's final. This is the one that's still in effect today. So the bottom plan is the one that you need to know. Under this plan, it adopts the model from the deeming rule, where there's a deadline to file an application and a deadline to secure marketing authorization. And those timelines are May of this year and May of 2021. So this is sort of how pre-market review is implemented more globally. And you need to really understand how this works in order to understand what the FDA has done with flavors, which we're going to talk about now. Because what the FDA has done with flavors is also related to pre-market review. Now, probably a lot of people have been following this. The FDA has recently finalized the guidance. The draft version of that guidance was released in March of 2019. The FDA accepted comments on it. You may have recalled late last year in September, the commissioner of the FDA, the Secretary of Health and Human Services, and the president all sat in the Oval Office and agreed that in addressing flavors, the FDA was going to remove all flavored e-cigarettes from the market. The FDA submitted its final guidance to the Office of Management and Budget in October, and it cleared OMB in November. Now, normally at that point, guidance would be published, it would show up in the Federal Register, and that didn't happen in this case. In fact, instead of that, there was a meeting that was held by the White House with public health officials and tobacco product manufacturers, and the guidance wasn't actually published until this month. And so we raised this just to show you that this guidance did not follow the normal policymaking procedures. And so the weak guidance that we have, you can't really necessarily attribute to the FDA. And we don't really know where the failures of this guidance are, and it doesn't really matter entirely. But this is just to say that when we refer to the FDA throughout the rest of the webinar, the fault may lie with the White House or OMB or the Department of Health and Human Services. This guidance was a mess throughout the process, and the policy that we end up with is kind of a mess as well. So you may remember that the draft version of this guidance would have seen the FDA put restrictions on some e-cigarettes that were flavored. and fewer restrictions on tobacco, mint, and menthol flavored e-cigarettes. The final guidance makes a few changes. First, rather than trying to restrict or not restrict products, it simply either removes products from the market entirely or allows them to remain on the market and be sold, which is actually a positive development. The other two changes are not necessarily positive. One is that the FDA has limited the scope of the flavored products that it's going to address to a category that it calls cartridge-based e-cigarettes, which we'll talk about in a minute. But the other one that's we're going to spend a little bit more time on is the decision to include mint in its action on flavors, but to continue to exempt menthol as a flavor, which is problematic. The FDA has been struggling with how to regulate menthol for a long time. We've seen state and local governments follow the FDA's lead in exempting menthol from action on flavors. It's not until the last few years, really, that we've seen action on menthol. So the federal government continuing to double down on that exemption is really problematic and really disappointing. So the FDA references a couple of data sets to justify the decision to exempt menthol. One of them is again, the National Youth Tobacco Survey. And that survey asks high school e-cigarette users about their preference for flavors. It uses a few broad categories. And as you can tell, because the percentages in a particular year add up beyond 100, it allows users to select any that they want. So what you will notice here is that preference for mint and menthol has been increasing over time. And this survey also includes those two flavors as one concept because they're very similar. And probably a lot of youth don't really understand the difference between them. The other data set that the FDA relies on is some data from another study called Monitoring the Future. And this was a study that was published by Adam Leventhal and his colleagues at the University of Southern California. And the Monitoring the Future survey used a module that asks questions of self-identified Juul users. And it asks them to identify not their preferred flavor, but the flavor they use most often. And it uses just Juul's flavors. Now you'll notice that broken into grade level, there's a clear increasing preference for mint among older students. And you'll notice that almost no one lists menthol as their preferred flavor. Now we have to take this data apart a little bit in order to really understand why you get these results. And as most of you know, in the highlighted portion of this timeline, which is most of the existence of Juul, they sold 8 flavors regularly, both in retail stores and on their website. But in November of 2018, Juul made a decision that remained throughout the course of this timeline to move some of its flavors just to its website. So crim, cucumber, fruit, and mango were only available through Juul's website. The other flavors, the 2 tobacco flavors, mint and menthol, were available essentially in any retail store. So again, that coincides with the decrease in Juul sales because prior to this point, mango had been Juul's highest selling product, likely the most preferred flavor among many youth. But once it moved mango to its website and out of retail stores, Juul actually couldn't keep up with demand for the new highest selling flavor, which was mint. And so it's important to know that the Monitoring the Future study and the National Youth Tobacco Survey were both conducted while this was the status quo. At that point, it was very hard to get a Juul branded mango pod because you had to buy it through its website. Probably there were cases where you could buy them from third-party vendors who were essentially selling counterfeit products. But if you went into a retail store, what was available to you was tobacco, mint, and menthol. Now, interestingly, Adam Leventhal and his colleagues included another set of data in their study. And this actually separates Juul users into 2 categories. Those who were using Juul less than 20 days per month, and those who were using Juul 20 or more days per month. And when you lay the data all out like this, you can see there's an escalating preference for mint, or I shouldn't say preference. They've identified mint as their most commonly used product for the older and more frequent Juul users. And if you really think about availability as the driving factor of use, not necessarily preference, and you separate all the flavors into the 2 groups we just showed, tobacco, mint, and menthol, those are available in retail stores, and then the other flavors only available on Juul's website, you can see a clear correlation between frequency of use and age and having to rely, or most using flavors available in retail stores. Probably because in order to satisfy your nicotine cravings, you have to go to retail stores that you know will sell. You can't rely on the website. So does this justify an exemption for menthol? Of course not, because if menthol remains in retail stores, youth are simply going to move to menthol rather than mint. Unfortunately, we don't have time to talk about the nuance between the differences between menthol and mint. But what we do know is that Juul used to sell mint and menthol. They've discontinued their mint product. And unfortunately, because of a bad decision in a case called Philip Morris v. FDA, we know that changes to packaging and labeling are actually outside of the FDA's pre-market review authority. So there's really nothing stopping a company from like Juul from changing its mint product and renaming it menthol, because the FDA has not defined the concept of flavor or mint or menthol in this guidance. There's really no way, especially when you combine this with the exception for changes to packaging and labeling, that the FDA can stop companies from relabeling these products. And if Juul doesn't do it, there probably will be companies that do. And if you don't have to take my word for it, because former Commissioner Gottlieb also believes this to be true. He said that it's likely that we'll see e-cigarette companies changing their products to be named mint or menthol, or changing the mint products to be renamed menthol. And he even speculates that some might change certain flavors to be labeled tobacco. And again, it's entirely possible. We might see that. Now, to talk about the other change here, which is that the FDA's action on flavors only refers to a subset of e-cigarettes, which it calls cartridge-based e-cigarettes. And in order to understand the scope of this, you sort of have to look at the definitions. But we'll get through these quickly, and hopefully this will make sense. So the FDA has a definition for electronic nicotine delivery system, or ENDS. It's a product that delivers an aerosolized e-liquid. E-liquid has a particular definition, but it doesn't really matter for our purposes here. So this is essentially all e-cigarettes. Now, a cartridge-based e-cigarette, according to the FDA's guidance, is a type of e-cigarette that involves a cartridge or pod that holds the liquid. Now, all e-cigarettes have something that holds the liquid, so this part of the definition doesn't really help you all that much in determining what's cartridge-based and what's not. So you have to look to what is a pod, and a pod is something that's designed to fit within the e-cigarette. So the definition is circular. A cartridge-based system has a pod that holds the e-liquid, and a pod is something that fits into an e-cigarette. So if you're confused, you should be, because this definition doesn't really tell you what it's covering. In fact, the only word in this definition that maybe gives you a hint is the word small, which is a relative term and doesn't really mean anything in this context. In fact, if you didn't know already from news reports what the FDA had exempted, you really have no idea looking at this language. And what the FDA's guidance says is that it is primarily the non-cartridge-based products that are sold in vape shops that it doesn't intend to cover. It doesn't use the word tank or mod, but probably that's what the guidance is getting at. And then bizarrely, you'll notice there's a footnote on that definition. And for some reason, the FDA's guidance also exempts what it calls completely self-contained disposable products, which are the sorts of e-cigarettes where you buy the device and liquid as one unit, use it up, throw it away, and buy an entirely new system. Why this is exempted is anyone's guess. There are lots of concerning products that come in a lot of flavors, and this guidance doesn't touch those products like Puff Bar. And then the other thing to talk about in this guidance, and unfortunately we won't spend a lot of time on it because it's a fairly discrete thing to discuss, but you may remember that the FDA's draft guidance was going to deal with flavors in cigars as well, which was a bold move, one that we applauded. It's beyond time to address flavors in harmful combustible products, but the FDA's final guidance decides not to address this problem at all, which is a huge failure. And remember, cigars are now the most commonly used combustible product among high school students. So all of the grape and peach Swisher Sweets and Black and Milds will remain on the market while the FDA is trying to address flavors in e-cigarettes. So just to sort of sum up, this guidance was unfortunately very weak. It only applies to a narrow subset of e-cigarettes, and it continues to double down on the harmful exemption for menthol. So what you have here is the two relevant pre-market review timelines. The top is for the flavored cartridge-based e-cigarettes, except mint and menthol, or tobacco and menthol. You'll notice they come off the market entirely next month, and those products can't re-enter the market until after they've been given authorization by the FDA. Now remember, this is the pre-market review process. This is not a comprehensive action on flavors. And so those manufacturers can apply for permission to market those products, and technically the FDA can grant permission. So this is also a temporary action. We could see flavored e-cigarettes re-enter the market in the future. And again, the bottom timeline applies to all other e-cigarettes, cigars, water pipe, and pipe tobacco as well. So manufacturers have until this May to submit applications. They have until next May to secure marketing authorization from the FDA. But we may reach a point in the near future where tobacco products that are sold in stores have actually had oversight by the Food and Drug Administration. Now we will talk about the new Tobacco 21 law, and I'm going to turn it over to Natalie.
Thank you, Desmond. Yeah, so as Desmond said, we're going to jump into the more exciting and hopeful federal change, and that's the federal Tobacco 21 law. And I just want to start off saying that the most important takeaway here is that as of December 20th, 2019, in all U.S. states and territories and on all tribal lands, the minimum legal sales age for tobacco products is 21, no exceptions. This is a great step forward for public health and an important policy change in the fight against youth addiction. Understandably, this is confusing, and we've gotten a lot of calls and questions about this change and how it works. And so I'm going to talk through some of the most common questions that we got and try to clear up some of the confusion. And I just want to start off saying, first, I get why this is confusing. As Desmond just demonstrated when he was talking about the flavors, that it's a complicated area of law, and sometimes it's just confusing how the federal government does things. So hopefully we can clear up some of that. The first thing that was particularly confusing is that while Congress unequivocally established the minimum legal sales age of 21 that had immediate effect, it also directed the FDA to update its own regulations around the minimum age so that the FDA would be fully and effectively enforcing the change in law. So even if Congress had not directed this, the FDA most likely would have made these changes anyway, but the direction gives the FDA a deadline for actually completing those updates to their regulations. This caused confusion by leading many to believe that the law would not be in effect until the FDA did finalize those regulations, but that's not true. As an analogy, you can think of a road where the speed limit is 45 miles per hour. Even if it's well known that cops never give a ticket unless you're going over 60 miles per hour, every time anyone goes over 45 miles per hour, you've still broken the law. So in the present situation, the FDA is not able to enforce the T21 until it updates its own regulations, but the law is still in effect, and anyone that sells to someone under the age of 21 is still in violation of the federal law. And it's important to also note that the FDA is continuing to conduct compliance checks with youth decoys that are under the age of 18 until they are able to use the decoys that are aged 18 to 20. And then the last thing to note is that based on the deadlines that Congress gave FDA for making the changes, the last possible effective date and implementation date of the FDA's enforcement of the law is September 15th, 2020. The FDA usually likes to get their ducks in a row before they put out statements or information about a policy change. And honestly, I was surprised to see that the FDA last week put out a news memo about the federal change. And I'm assuming that there was enough upheaval and confusion directed at the FDA that they were sort of backed into a corner to putting out this statement that would hopefully clear up some of the confusion. And in that statement, the FDA makes it very clear that the legal sales age for tobacco products is now 21 everywhere. The FDA acknowledges that they won't be able to use the youth decoys that are ages 18 to 20 until they make those updates. However, retailers should comply with the increase and only sell to those aged 21 and older, and check IDs for anyone who looks under the age of 30. And that change is immediate. A second area of confusion is how this change interacts with state and local laws. And the best way I can think to describe this concept is to think about the different levels of government as layered areas of law everyone has to comply with. The person, or in this case, most commonly the retailer complying with the laws, has to comply with the most stringent law that applies to them. In this case, no community has set the minimum legal sales age beyond 21, so the most stringent law is the federal law. Walking through an example, suppose you're in Minnesota where the state minimum legal sales age is 18. A retailer in Minnesota sells to someone aged 22. That is a legal sale because it has not violated any applicable law. It hasn't violated the federal law or the state law. If the same retailer sold to someone who was 17 years old, similar to the first example, there's a congruent violation of both state and federal law. But in that same example, if a retailer in Minnesota sold to someone who is 20 years old, the result is that although they haven't violated the state law, they have violated the federal law, and the sale remains an illegal sale. The same plays out in a state that has a military exemption. The federal law supersedes the state law and does not give an exception. If a retailer sold to someone with an active military ID in California that was 20 years old, it would be a violation of the federal law, which doesn't give an exception, but not the state law. But ultimately, it would be an illegal sale. If you are not complying with any level of government's law that applies to you, you're breaking the law. Another area of confusion is which the next steps be for tribes, states, and local governments in response to the federal change. The federal law is not preemptive, so other governments that have not already adopted Tobacco 21 are free to also raise the minimum age. And this will most likely clear up confusion for retailers and those who are trying to enforce the law. Your state and local enforcement agencies don't enforce federal law. So to enforce the minimum legal sales age of 21, states and communities with authority to do so can amend or pass their own laws to mirror the federal change. As I said before, the FDA's own updates may take several months, and there's no legal reason to not align with the federal law now by moving forward with raising the minimum legal sales age. It's also worth noting that the minimum legal sales age does not prevent a community from going further than the federal law, as I previously mentioned, by raising the age to something higher than 21, just like we saw when states and localities doing when the federal minimum legal sales age was 18. One more question we've gotten frequently is, what about state law that specifically preempts local governments from adopting Tobacco 21? In those circumstances, there should be a careful evaluation and analysis of how the federal law interacts with the specific state preemption law. But aside from that, this might be an excellent way to drive a conversation about repealing preemption in those states, which is always a good thing. Even with preemption at the state level, this doesn't mean that it's legal for a retailer to sell to someone aged 18 to 20 in that community. It just changes what may need to happen in the state law before a community can pass its own ordinance. If you're a tribal government, there's nothing stopping you either. Federal law is effective everywhere, so in this case, it's a violation of federal law to sell commercial tobacco products to anyone under the age of 21, even on tribal lands. The tribes can exercise tribal sovereignty by establishing a minimum legal sales age of 21 or above and enforce that as a matter of tribal law as well. One final question we've been receiving is, what are the penalties for violating the federal T21 law? And these penalties are the same penalties prior to the change in law. There's an escalating warning, civil monetary penalty, and no tobacco sales order structure for any time a retailer fails a compliance check. The only change will be the age of the decoy buyer. The current fee schedule is available on the FDA's website. Comprehensive protection nationally for youth is a great achievement in public health and the fight against the death and disease caused by commercial tobacco use. The success on T21 is a perfect example of how pivotal starting at the lowest level of government can be. T21 began as a few local communities in Massachusetts, grew from there into eventually statewide policies, and now is the law of the land. Is not only a measure that will help protect kids, is not the only measure that will help protect kids. Best practices show that flavor restrictions in all commercial tobacco products, density restrictions, addressing the school environment, and penalties are also important to consider when making tobacco control laws. However, this is a win and we should all celebrate. The last wrap-up item is that you can report any potential violation of either the limited flavor ban that Desmond was discussing or a violation of the National T21 law to the FDA through their website. They have a handy online portal that I've screenshotted here, and I've included the link because, as we mentioned, the webinar slides will be available on our website after the webinar, so you could click through the slides as well to get to it. And we just ask you to please visit our website, thepublichealthlawcenter.org, and navigate to our FDA Action Center to find resources about these changes that Kira mentioned in the beginning, including the archived version of this webinar and our latest blog posts on the topics we've covered here, and more about pre-market review. So now we're going to open it up to questions. And we will try to have answers.
Hopefully people have been submitting questions. We'll have Kira throw us a couple of questions, hopefully, that have been coming in. But again, if we don't have time to get to all the questions, definitely feel free to shoot us an email or give us a call. We can definitely talk through these policies. There's a lot of moving parts. There's a lot to try to keep straight.
All right. One of the first questions is there a real difference between mint and menthol flavors? You mentioned that this is a difficult question to answer. Can those products just be relabeled?
Yeah, we kind of punted on that. So this is the way that I've always thought about this. Menthol is a particular flavor component, I should say. I'm not a scientist, so I'll do my best explaining, but menthol is a particular flavor component, and it's present in most mint-flavored, foods and candies. It's the active smell and something like Vicks Vapor Rub, but it's also in things like eucalyptus. So if you think of like Hall's cough drops, that cooling, smoothing sensation, that's menthol. Mint is, a variety of plant species, spearmint, wintergreen, and it's sort of there are other components in there besides menthol that create that flavor. Now, that's the broad distinction between mint and menthol. If you drill down into something like Juul pods, for instance, there's a study out there where a group of scientists took the pods and did a chemical analysis of all of the different stuff that's in them. And if you line up mint and menthol, they have a lot of the same flavor compounds. Menthol is only one of the particular flavors. So without, an organization like the FDA having some sort of comprehensive definition of where the line between mint and menthol is, there's really no way to know, even when you have all the information in front of you of what's inside the products. And so that's the problem with providing any exemption for any type of flavor. There are a lot of flavors that are going to be able to say that they are that flavor. And related to packaging and labeling changes, we saw this happen in the local governments that had passed flavor policies. You saw a lot of cigars and e-cigarettes that suddenly had flavors like jazz and summer breeze and all the sorts of concept flavors that we saw. And unless you have a clear flavor name like something like grape, it's hard to enforce those laws. And so this exemption for menthol is certainly going to drive some products to relabel things like mint as menthol. And there's no question that we're going to see more disposable products in stores as well. So the FDA's flavor policy is full of holes.
And that's another important point of just flavors in general, that the federal government wasn't learning the lesson that a very comprehensive and specific definition of flavors is very important, and local jurisdictions experienced that and really worked out some of those kinks. This idea that you could just change a label so that your tobacco product did not look like it was flavored, but in actuality it was. So it's a huge oversight to not define what some of these terms mean, and it leaves open industry malfeasance for sure.
Will local and state law enforcement enforce T21 in states that have originally had T18? And then relatedly, is the legal age to possess tobacco products also changed to 21 as well?
So in states and communities that don't have the legal sales age of 21 in their ordinance, it's unlikely that they would be enforcing that because that's the federal law. So if they want to enforce 21 in their state or in their city or county, then, or tribal government, then they can also pass an ordinance. That's the clearest and easiest way to actually be able to enforce it, because it's really the federal government that would be enforcing the federal law. And then the second part of the question was what happens with some other things that seem to be related. And so penalties for youth. There's never been any federal penalties for youth who purchase, use, or possess these products. And so, and that will continue to be the same answer, that it depends on what the state and local law is around those provisions. And we would advocate for actually removing those provisions. But also the federal government has never addressed that, and they don't address that in this amendment either.
In what way does T21 change how SINAR works?
Go ahead.
You probably saw, if you were following the news closely. So obviously the big news is that now Tobacco 21 is the law of the land, and the FDA will be enforcing it. But that same law made some changes to the SINAR provisions as well. So that's in case you don't know, states get block grants through the Substance Abuse and Mental Health Administration, and they are required to do tobacco compliance checks and have particular compliance rates in order to get their entire block grant. This program was initially used to sort of force states to pass a minimum legal sales age for cigarettes back in the 1990s. So this law takes SINAR and makes some changes. It forces the SINAR inspections to use 21 as the age that they're checking compliance for, but it does not force states to change their laws like the original version of the policy did. So what will be happening in the states is that you will have the FDA and its enforcement contractors going in to do retail compliance checks eventually with 21 as the age. Those checks, any violations in those compliance checks can result in penalties to retailers from the FDA. The SINAR checks are just information gathering, and they're just for block grants. So the SINAR inspections will also be checking for compliance with 21. They'll be sending in youth who are under 21 to see if retailers sell to people who are under 21. And they'll use that to gather information to test for compliance for these block grants. But again, neither that program nor the FDA's program actually require changes to state or local law. It is up to states, tribes, and local governments to affirmatively change their laws if they want to actually enforce 21 with their own enforcement agencies.
Does T21 apply on military bases, and can states exempt members of the military from the T21 law?
Yes, it applies on military bases, and states cannot exempt. There's no exceptions in the federal law, and so the federal law establishes the floor. And so if the state has an exception, as I showed on the one slide, it would be a violation of federal law to sell to someone with a military ID that is 18 to 20 years old, but wouldn't necessarily be a violation of state law. So if the state enforcement agencies wanted to enforce at the same level as the federal government, then they would need to remove that exception.
And are both of these new
policies in effect on tribal land as well?
Yes.
Desmond, you mentioned that the flavor ban is effectively only temporary. It's not mentioned in FDA's guidance that the ban was temporary, and it seemed that it was indefinite. Can you clarify?
Yeah, no, that's a good question, because we sort of glanced over that issue a little bit. So because the FDA is using pre-market review as the tool, this is not a rulemaking. This is not the comprehensive action that was part of the FDA's new regulatory plan. The FDA is using pre-market review. And again, because e-cigarettes and other products subject to deeming that have not yet secured their marketing orders are being sold technically illegally, and the FDA is just allowing them to be sold, the FDA can decide at any point to revoke that discretion and decide to remove the products from the market. But in doing so, it only requires them to go through the pre-market review process. So if the FDA proposed a rule and said comprehensively, there are no flavors allowed in e-cigarettes, that would be indefinite, and you could never introduce or sell a flavored product. But here the FDA has said, we are targeting these products for pre-market review. And so you must remove them from the market now, but manufacturers can still apply to the FDA to market those products in the future. And it is possible that the FDA could grant them authority. I say possible because there's a high standard in the law in order to sell a new product. You more or less have to demonstrate that will have benefits to public health. So if you imagine a product like Juul, it should be difficult or probably impossible for them to secure marketing authorization, given what we know about the impact of their product, particularly a product that's flavored mango or something else that we know is youth attractive. But the way that the law is written, it is possible that a manufacturer could get marketing authorization in the future and sell those products again. It's whether or not the FDA grants marketing authorization that will decide whether or not that's the case.
In the flavor guidance, FDA states that companies that do not cease manufacture, distribution, and sale of unauthorized flavored cartridge-based e-cigarettes other than tobacco or menthol within 30 days risk FDA enforcement actions. Any idea what those FDA enforcement actions would be?
So the way that we assume the FDA will enforce this is if you are in the retail setting, so take Tobacco 21, for example, a retailer who sells a product to someone who's under the minimum legal sales age has violated a particular part of the regulations. And as Natalie mentioned, there's sort of a set penalty schedule for that. Because pre-market review is not centered on one sale, it's centered on the product itself. If companies are required to take a product off the market and they don't, it is the product itself that creates the violation. The FDA decides that the product is misbranded and adulterated. Those are the legal terms for this. And so any future sale of that product in any context is its own violation of federal law. And so there's a different schedule of penalties for that type of violation, and they're very stiff. So if the FDA declares that a particular e-cigarette brand, that a particular product is misbranded and adulterated, and a manufacturer continues to sell that product, they would see their penalties stack very high very quickly.
And that penalty is most commonly issued against the manufacturer in this circumstance.
Right.
If someone reports a violation of T21 to FDA prior to the rollout of their final rule, will they be permitted to enforce those violations?
That's a good question.
I mean, the way that I imagine reporting will, I guess I don't know. I don't know the answer, maybe legally or technically, but like how I imagine it working if you report to the FDA a violation of T21 is that hopefully then that location will be like high on the list to have a youth decoy that is 18 and 20 to go into the store when the FDA does have the authority. That will be sort of a high prioritization to check that store to ensure that they are complying with federal law. Because I don't think that the FDA probably wants to get into the sticky business of in between, but when they do have the authority, I would imagine that would be sort of the approach to taking that report of a violation.
I think that's probably the right answer. I think the FDA is going to be, they're not going to want to be doing pretty thorough enforcement when you have a statute that says 21 and the regulations say 18. They're going to want to get that regulation updated. But I think you're right that if there are known bad actors before they finalize those regulations, those bad actors are going to be on the top of the list probably for inspections.
And I think you should still report them for that reason.
Absolutely.
Does the federal
Maybe one or two more questions?
Does the federal T21 regulation give local, city, or county law enforcement authority authority to enforce the new T21 law? And if so, when can and should they start enforcing?
No, because it's the federal law, so the federal government will enforce the law. And so if communities are interested in enforcing T21, the best way to do that is to go ahead and pass their own ordinance or their own statute that establishes that in their community. It's also a violation of their community's law or their state's law to sell to anyone under 21 as well.
Would the new flavor guidance apply to refillable pod systems, i.e. pods that are sold empty and can be filled by the user?
That's a good question. It doesn't look like it does. I mean, we sort of walked through the way that the guidance defines cartridge-based ends, and it seems that what the FDA is trying to exempt is systems that are refillable for the user. And I mean, there's a logic to targeting Juul and products similar to Juul. Obviously, those are the primary cause of the youth epidemic. But, you know, we all know there are products like Soren, which is refillable. There are products like Puff Bar that are disposable. And so drawing the line just around Juul is not going to alleviate the problem. I mean, the answer to the question is that it seems as though, yes, the FDA is exempting those particular products. So, you know, this again underscores the need for comprehensive regulation of flavored products at the federal level, and in the absence of that, action at the state and local level as well. This is a half measure that does not fully address the problem it sets out to address, and again is also temporary because it's related to pre-market review and is not a comprehensive action.
And I think this also sort of goes back to the point that I made before about the lack of comprehensive definitions is really apparent in this guidance. And so the definition is confusing. And so we are coming up with the idea that the FDA or the federal government intends to exempt certain products, but that's coming from reading the whole thing and not clearly from the definition. So that's sort of another oversight of the poor drafting of that.
All right, well, I think we're out of time. Thank you everyone for tuning in and for joining us. Again, we're recording this webinar. You'll be able to get the slides as well. And if you have any questions about this information in the future, again, we have resources on our website and you can always feel free to reach out and ask us questions.